Hello everyone, I am Ankita, a qualified CMA. I am here to help you prepare for your exams in a simple and effective way. My area of interest is law, and I'll be focusing on that subject to support your CMA intermediate preparation. So let's begin with one of the most important topic of company law. It's Companies Act 2013. We'll start with the introduction to this act and gradually cover the key concepts. So in this video we are only going to cover the basics of Companies Act. Earlier we were having Companies Act 1956. This was amended to Companies Act 2013. Why do you think it was amended? So, according to 1956, there were so many sections. These sections are reduced in 2013 Act. As sections were reduced, what happened? As sections were reduced, the clauses and rules were increased in 2013 Act. Now let's understand what does the word company means. What is a company? What is a company and what is its origin? What do you think? The word company came from a Latin word which come plus panis. What do you mean by come? Together. Come means together. Panis means bread. What do you mean by this? Eating bread together. It's a ritual followed by, I think it's a ritual followed by Latin peoples. It's like just come and have the bread together. So what does it actually mean in simple words? An association of persons. An association of persons who took their meals together. So in general, the meaning goes with, let you guys will speak like, let me give you the company, like giving company. The concept of companies was taken from English Companies Act 1844. The concept was taken from this act, and in 1850 first company law in India was implemented. What does it stated? It stated about joint stock companies. Joint stock companies. What happened next? In 1857, JSCA 1850, this was replaced. It is repealed. Why do you think it was repealed? For the first time, they introduced limited liability concept. It was replaced by JSCA 1860. This was introduced banking companies. They introduced banking companies in 1860 JSCA. What happened in 1866? First Comprehensive Act was introduced. What this does? All the provision all the rules were introduced. For the first time, all provisions and all rules were introduced in 1866. In 1882, it was recasted and it was in force up to 1913. In 1913, officially, Indian Companies Act 1913 was introduced. All several amendments were every day they made amendments to this by following English Companies Act 1908. By following this act, they made amendment to this act. Every day they made the amendment so that the act became effective and useful to the users. How the 1956 came? In 1956, Companies Act was passed. Companies Act 1956 was passed. This was purely based on English Companies Act 1943. This act is purely based on English Companies Act 1943. What is there in in Companies Act 1956? There are, how many sections are there? There are totally 658 sections, 15 schedules with 26 chapters. Don't you think 658 sections are too many to study? Again, this was amended. This was amended to Companies Act 2013. There was total 25 amendments to bring this act from this. To bring this to this, there were 25 amendments made. For this implementation, there were so many company bills were passed, many notifications were introduced to implement the act properly. Now, what do you think? What is Companies Act 2013? What changes did this brought to 1956 Act? It was Act number 18. There were total 29 chapters. How many sections were there? There were 470 sections. There were 7 schedules. In old, there were 26 chapters, 658 sections, 15 schedules. Let's start with the introduction. Company. Companies are always categorized into two. What are those? One, corporate form. Other one is non-corporate form. One is corporate, other one is non-corporate. What does this corporate means? What are included in this? The cooperation organizations, and in this we include the company. What does this non-corporate form means? Here comes the HUFs, partnerships, sole proprietors, mutual agencies. We are going to study about this company right now. Section 2, subsection 20 of Companies Act says about company. What the definition of company? What is the definition? Companies incorporated under this act. Any company which is incorporated under this act or under any previous company law. Any previous company law. Which was the previous company law? We have studied. It is English Companies Act from 1844 to 1956, whatever it may be. From that period, whichever company was registered, those all companies come under this definition. Companies law. Let's even write the meaning of company. A simple meaning which is easy to understand. Company is a voluntary association of persons formed for the purpose of doing business, having distinct name and limited liability. Company is just a voluntary association of person. Voluntary association of person. Voluntary association of person formed for purpose. There should be a purpose so that the people come together. Voluntary association of person formed for the purpose of doing business. Doing business means making profits. Everyone do business to make profit, right? Doing business, having a distinct name and liability. Everyone's liability are different. Some are limited, some are unlimited. But in company, you don't have any unlimited liability. It's always limited. Now, let's start with the characteristics of company. It's easy, guys. It's very easy. The first characteristic is separate legal entity. What is separate legal entity? Company and members both are different. They are not same. Company, members. There is a wall between this. We cannot consider the member as the company. Company and members both are the same. Members are nothing but the shareholders who invest in the company. Both are different. A company is an artificial person. Company is an artificial person. It is not a natural person. It has its personality, having a personality which is distinct from its members. Always the personality or whatever, if there is a shareholder, suppose if a shareholder died, it doesn't mean that the company is gonna stop or the operations are gonna stop. Nothing happens to the company. Even if all the shareholders die, company will run unless and until company is winding up or dissolved. Company can run even though if the shareholders are died, because ultimately companies are run by the directors and not by the shareholders. Shareholders are those who only invest in the company. They don't look after the company. They appoint the directors so that they can manage all the operations of the company. Let me give you an example. You bought a SIM. Suppose it's Jio SIM and you did not get proper services. Do you go to the shareholders that I didn't get the proper services? Of course, you'll go to the company. You don't complain it to shareholders. You'll go and complain it to the company. Whichever department is responsible, they'll take care of it. You cannot go directly to the shareholders, because company and members both are the different persons, not the same. And company has distinct legal entity. It is independent of its member. What can a company do? A company can own property. It has the right to own property. It can go into contracts. Company can make contracts. It can even file suits. It can even file suits in its own name, only with the name of the company, not with the name of the shareholders. This can be done by the company. In real sense, the members are just the owners of the company, but it is ultimately managed by the directors who are elected representative of its member, because it is absolutely necessary for it to have a human agency called board of director. The board of directors runs the company. What do you mean by board of director, guys? What do they do? They prepare the annual budgets, compensation arrangements of top officials. They elect the CEO by casting their votes. They are responsible for the overall performance of the organization. We'll study it later. And now there is a case law for this. It's